SEC Rule 10b5-1, codified at 17 C.F.R. 240.10b5-1, is a regulation enacted by the United States Securities and Exchange Commission in 2000. The SEC states that Rule 10b5-1 was enacted in order to resolve an unsettled issue over the definition of insider trading, which is prohibited by SEC Rule 10b5. Different courts of appeals had come to different conclusions about what constituted insider trading under Rule 10b5. Specifically, whether someone could be held liable for insider trading simply by trading while in possession of inside information, or whether a trier of fact must find that the person actually used that inside information when making the trade. Possession versus use paragraph of the rule essentially repeats the holding of the United States Supreme Court in United States v. Oregon, 521 U.S. 642, which defines insider trading under the misappropriation theory. It states, in full, that, paragraph addresses the unsettled possession versus use issue, stating that a person violates Rule 10b5 simply by trading while in possession of inside information. It states, in full, that, in other words, under 10b5-1b, a person could be liable for insider trading simply by possessing inside information regarding a given security, breaching a fiduciary duty to the source of the information, and then trading it with a self-serving intent, even if he or she would have made the trade anyway. See United States v. Oregon, 521 U.S. 642, 652. But it is unlikely the SEC will detect or particularly care about a small trade that would have occurred anyway. A large trade or series of trades that reap unusual benefits for a trader, however, will likely be detected, and it would be difficult to prove that the material non-public information did not contribute to the decision to make the trade. Affirmative legal defense for planned trades. In paragraph, however, the SEC created an affirmative defense to any charge of insider trading, designed to cover situations in which a person can demonstrate that the material non-public information was not a factor in the trading decision. The provision allows an affirmative defense to insider trading when the trade was made pursuant to a contract, instructions given to another, or a written plan that, d. It not permit the person to exercise any subsequent influence over how, when, or whether to effect purchases or sales, 1, I, b, 3, and where the plan was created before the person had inside information. For example, a CEO of a company could call a broker on January 1 and enter into a plan to sell a particular quantity of shares of his company's stock on March 1, find out terrible news about his company on February 1 that will not become public until April 1, and then go forward with the March 1 sale anyway, saving himself from losing money when the bad news becomes public. Under the terms of Rule 10b5-1b, this is insider trading because the CEO was aware of the inside information when he made the trade. But he can assert an affirmative defense under Rule 10b5-1c, because he planned the trade before he learned the inside information. A possible loophole: cancelling plans. After Rule 10b5-1 was enacted, the SEC staff publicly took the position that cancelling a planned trade made under the safe harbor does not constitute insider trading, even if the person was aware of the inside information when cancelling the trade. The SEC stated that, despite the fact that 10b5-1c requires trades to be irrevocable, there can be no liability for insider trading under Rule 10b5 without an actual securities transaction, based on the U.S. Supreme Court's holding in Blue Chip Stamps v. Manor Drug Stores, 421 U.S. 723. This staff interpretation raises the possibility that executives can exploit this safe harbor by entering into 10b5-1 trading plans before they have inside information while retaining the option to later cancel those plans based on inside information. Although paragraph 1(i)(c) does deny the affirmative defense to offsetting or hedged transactions, in that case there would still be an actual trade that could constitute insider trading and violate Rule 10b5. The SEC's position is that there can be no insider trading without a trade, so that a person could cancel a planned trade based on inside information and avoid liability. although technically any plan that is cancelable does not come under the 10b5-1 safe harbor, proving that an executed trade was hypothetically cancelable might be very difficult. A few academic commentators have written about this issue, arguing that insiders can make systematically above-market profits by using 10b5-1 plans that they are still able to cancel. One empirical study has found that insiders using 10b5-1 plans do in fact make above-market profits, and another has found that the presence of publicly announced 10b5-1 plans has economic effects on securities markets that are generally associated with insider trading. Others contend that rather than timing trades, executives may time news or press releases to move the stock before a 10b5-1 plan sale. SEC reaction, noted in a speech by Linda Chapman Thompson, the SEC Chief Enforcement Officer. The SEC is now investigating why 10b5-1 trades appear to outperform the market. Allegations of improper 10b5-1 trades were noted during the insider trading trial of Joseph Nacchio, former Quest CEO. There are also preliminary investigations into 10b5-1 trades by Angelo Mosillo from Countrywide Financial. The SEC sent a Wells notice to Mosillo in May 2009, suggesting intent to pursue civil charges in relation to alleged illegal trades through his 10b5-1 plan. On March 25, 2009, the SEC staff revised its interpretative guidance regarding the circumstances under which the affirmative defense in Rule 10b5-1(c) is available. In particular, the staff followed the approach previously urged by some commentators to clarify that the cancellation of a 10b5-1 plan could call the good faith of other, executed plans into doubt, and that the Supreme Court's decision in Blue Chip Stamps v. Manor Drug Stores, 421 U.S. 723, did not affect the SEC's ability to bring an enforcement action against a would-be insider trader who cancelled a trading plan and did not trade in a particular transaction because a subsequent decision, Merrill Lynch, Pierce, Fenner & Smith, Incorporated, v. Daubert, 547 U.S. 71, made clear that blue chip stamps dealt only with the implied private right of action for violations of Rule 10b5 and not the in connection with requirement for all Rule 10b5 violations. References